Hello, everyone, and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Uli, and this is episode 129 of the Forge of Freedom. Today, I've got an article to share with you by Wanjiru Njoya from the Mises Institute, and I'll link to this, of course, in the show notes so you can go read the article for yourself. But this article touches upon a topic that came up during a recent episode with Michael Rechtenwald. I believe that was episode 125, and I'll go back and link to that episode as well. But Michael Rechtenwald is a libertarian candidate for president, and of course he's busy at the Libertarian National Convention this weekend. But during that episode, we talked about the concept of the non-aggression principle, which many libertarians put forth as the sort of the foundational principle of libertarianism. But I suggested, and he agreed, that that's not really where it begins. It begins with self-ownership. And I've talked about this concept on a number of occasions on the podcast. But the idea is that each person has a superior claim to their own body as compared to everyone else in the world except for God, if you believe in a God. But with respect to every human, each person has a superior claim, a superior right to their own body, self-ownership. And from that, or beyond that, we also have the right to the product of our own labor, the things that we create out of our self-ownership, with our own labor, our own effort, and that's by extension. And then thirdly, there's the non-aggression principle, which is that I can't aggress against somebody else's property. That would be a violation of their self-ownership. And so the non-aggression, the idea is that the non-aggression principle is really nonsensical unless there is something to aggress against, and that's property rights, beginning with self-ownership. So this article by Wanjiru Njoya is called Property Rights and the Will to Own. And again, it's at the Mises Institute website, mises.org. So let's get into it. Jeremy Bentham famously regarded natural rights as nonsense on stilts, and taught that property rights are created by law and enforced by courts. Bentham's view was that before the laws, there was no property. Take away the laws, all property ceases. Lawyers in the Benthamite tradition accordingly set out to define the state-created nature of property rights and the boundaries of these rights as defined by the courts. The elusive nature of property has long confounded common lawyers who conceptualize ownership not as dominium in the Roman law sense, but instead as a bundle of property rights created by the state. For example, Kevin Gray observes in the Cambridge Law Journal that property is not a thing. It is the bundle of rights that comprises the property. He proceeds to ask, but what are the rights in the property bundle? Or more accurately, wherein lies the property character of the rights in the bundle? What constitutes the propertiness of property? Common lawyers would answer that question by identifying the elements recognized by courts as components of that bundle of rights. In Boundaries of Order, Butler Schaffer argues against the Benthamite notion that property rights are created by the law. Schaffer argues that property rights play a foundational role in social order and social interaction, a view that is entirely compatible with the classic common law analysis of property. However, Schaffer differs from the Benthamites in rejecting the role of the state in creating and defining property rights. Instead, Schaffer sees property rights as an expression of what he calls the will to own. The will to own is an expression of the human will and is essential to human liberty. On that basis, Schaffer defines ownership as follows: A claim of ownership is the assertion of one's will, addressed to others, to be the exclusive decision maker over oneself of some resource, to have what one claims be immune from trespasses by others. Ownership as a social concept. Schaffer sees ownership as a social concept in the sense that when we assert a claim to ownership, it is to others that our claims are directed. This aspect of ownership as a social concept accords with the interpretation of property rights in the case law dominated English common law tradition, as the content of property law is largely constructed by courts to resolve disputes between, for example, the owner and a trespasser, rather than to advance any philosophical or ideological theory of property. Property litigation was not historically about theoretical ideas on the nature and origin of property rights, but primarily about how to settle very practical issues in contest between two parties. In that context, the notion of excludability is key to Gray's analysis of the common law of property. In his example, the lighthouse keeper may control access to the benefit of the light by the simple action of or inaction of never switching on the light. Somebody may have property in the lighthouse, but nobody can have property in light. Excludability is not only a question of whether it is physically possible to exclude others from the resource, but also, as Gray observes, includes a moral element. In his example, not only is it physically impossible for the lighthouse owner to exclude others from seeing the light he emits, but it would also violate basic moral principles. In appropriating light, air, or water, following such appropriation, there would not, in Locke's well-known phrase, be enough and as good left in common for others. Gray's analysis, however, errs in its subtle shift from property as a set of social relations to property as a construct of state authority and power. Gray depicts property rights as mere moral or social rights that can be abridged or overridden by other moral concerns or by more highly rated social objectives, including political standards which enrich life. Gray sees property as a relationship between three people: the property owner, the trespasser, and the state expressing its collective judgment through the voice of the courts. The importance of self-ownership. By contrast, Schaffer emphasizes that property rights reflect not state edicts, but the will to own. On this point, Schaffer's analysis has great explanatory power, as he rejects the idea that the state is a third participant in the social relations through which ownership claims are expressed. Schaffer argues, on the contrary, that law and rights do not depend on the dictates of the state. Schaffer conceptualizes property rights as ownership claims addressed to others in the course of social and market interaction and exchange, arguing that property rights are decided through the process of human interaction rather than being decided by the state. He identifies several difficulties that would arise if the state had the prerogative to dictate claims to ownership. For example, if the state is to decide what is or is not property, what is to stop the state from declaring, should that be the democratic will, that human beings are chattels? Only the concept of self-ownership stands between each individual and any attempt by the state to enslave him. As Schaffer explains, while almost all thoughtful men and women now condemn these earlier practices, there has been little awakening to the importance of asserting the case for self-ownership. To the extent that we deny our own self-ownership, we have not ended slavery, but only redefined it. By subjecting our lives to the control and management of institutional authorities, particularly the state, we have done little more than transfer our allegiance to new masters. Schaffer defines self-ownership as the assertion of one's will to have exclusive power and control over one's life. Schaffer is not referring here to the natural rights that Bentham described as nonsense on stilts, but rather to very practical concerns, namely the need of all living things to occupy space and ingest energy from their external world by defining their boundaries and refraining from encroaching on the space of others. A basic aspect of all social interaction, Schaffer argues, that because we are social beings who can sustain ourselves only by the individual consumption of resources, the property principle is at the core of our well-being. Understood in that way, and in particular by seeing property rights as a construct of self-ownership, it becomes clear that property rights do not depend on laws or any state edicts. The state, on the contrary, intervenes in such social interactions to regulate or control ownership claims, ostensibly to promote order, security, or other public goals. This leaves citizens at the mercy of whatever the state decrees to be or not to be property rights. In that light, the state should not be seen as the source of property rights, but as a threat to them. So that's the end of the article there. Like I said, I think that this article is helpful in shedding some light on the primacy of this concept of self-ownership. And I think that this focus, this laser focus on the fundamental principle of self-ownership is largely what distinguishes libertarianism, at least libertarianism with a small L, from other political theories like conservatism or progressivism. Those theories, at least the practitioners of those theories, seem to just wander and have very little consistency in their political viewpoints or opinions, largely because they don't act based upon a guiding principle like self-ownership. Now, you could identify some principles of conservatism or progressivism. Maybe it's egalitarianism from John Rawls, but I think largely today's political discourse is mostly incoherent, mostly because it's not guided by fundamental principles. And so that's, to me, one of the huge appeals of libertarianism. Obviously, we shouldn't seek consistency just for the sake of consistency. But I think that there's also compelling philosophical and logical reasons for the argument for self-ownership. And so I think that this is something that needs to be considered more often when we are assessing what political action should or should not be taken. And generally, the expansion of the state, whether that's at the behest of conservatives or progressives, is an increase in the amount of infringement on property rights, and an increase in the degree of infringement on self-ownership. All right, I hope that this gave you some food for thought. I hope you enjoyed that article, again, by Wanjiru Njoya. She, just for those of you wondering who she is a scholar in residence for the Mises Institute. She's the author of Economic Freedom and Social Justice. She's also the author of Redressing Historical Injustice. And she has spoken on many occasions at law schools and various places around the world, and on other podcasts. I'll try to link to a few of those in the show notes as well. So definitely encourage you to check out her work in addition to this article. All right, everybody, thanks for tuning in. As always, you can find the show on YouTube, Facebook, Rumble, and all the most popular podcast streaming platforms. I hope you'll tune in again for Monday Gun Day. Should be back on with Mike Uli again this week for episode 130. Thanks, everybody, for tuning in. If you liked it, don't forget to like and subscribe to help us spread the message of freedom. And until next time, remember, you are the forge of freedom.
Thanks for listening to this episode of Forge of Freedom. Be sure to subscribe wherever you heard this podcast so you never miss a future episode. For more information or to connect with Alex, you can go to forgeoffreedom.com or follow him on Twitter at Forge of Freedom. Until next time, remember, you are the Forge of Freedom.